5 seconds to go. Start. Court was concerned with the meaning of the word appear. The court held that the appropriate meaning of the word appears is seems. It imports a lesser degree of probability than proof. In Ram Singh versus Ram Nivas 2009, 14 SCC 25, a two-judge bench of this court was again required to examine the importance of the word appear as appearing in the section. The court held that for the fulfillment of the condition that it appears to the court that a person had committed an offence, the court must satisfy itself about the existence of an exceptional circumstance enabling it to exercise an extraordinary jurisdiction. What is therefore necessary for the court is to arrive at a satisfaction that the evidence adduced on behalf of the prosecution, if unrebutted, may lead to conviction of the persons sought to be added as the accused in the case. At the time of taking cognizance, the court has to see whether a prima facie case is made out to proceed against the accused. Under section 319 CRPC, though the test of prima facie case is the same, the degree of satisfaction that is required is much stricter. Power under section 319 CRPC is a discretionary and an extraordinary power. It is to be exercised sparingly and only in those cases where the circumstances of the case so warrant. It is not to be exercised because the magistrate or the sessions judge is of the opinion that some other person may also be guilty of committing that offence. Only where strong and cogent evidence occurs against a person from the evidence laid before the court that such power should be exercised, and not in a casual and cavalier manner. Thus, we hold that though only a prima facie case is to be established from the evidence laid before the court, not necessarily tested on the anvil of cross-examination, it requires much stronger evidence than mere probability of his complicity. The test that has to be applied is one which is more than prima facie case as exercised at the time of framing of charge, but short of satisfaction to an extent that the evidence, if goes unrebutted, would lead to conviction. In the absence of such satisfaction, the court should refrain from exercising power under section 319 CRPC. The degree of satisfaction required to exercise power under section 319 CRPC is well settled after the above referred decision. The evidence before the trial court should be such that if it goes unrebutted, then it should result in the conviction of the person who is sought to be summoned. As is evident from the above referred decision, the degree of satisfaction that is required to exercise power under section 319 CRPC is much stricter, considering that it is a discretionary and an extraordinary power. Only when the evidence is strong and reliable can the power be exercised. It requires much stronger evidence than mere probability of his complicity. In this background, we will examine the evidence on record which prompted the trial court to exercise the power under section 319 CRPC. PW1, who is the mother of the deceased, is the only witness who has named the appellants. Stop.